Good morning, Your Honors. May it please the court, I would like to reserve 5 minutes to respond to the appellee's argument.
Sure.
I represent James and Janice Lighton in this appeal. A couple things to consider as the court listens to the oral argument. We have the new summary judgment standard. We all are familiar with what the new standard is, and the key issues as they apply to this case are very simple. Could a reasonable jury, based on the evidence presented in the record, find for the appellants? That is exactly what was said in the amendments for the rule for civil procedure.
Let me jump in on that very point, Mr. Land.
Yes, sir.
Can you point me to what you would rely on to indicate that there was some sort of undue, untoward influence?
Yes, Your Honor.
I would be happy to do that. Daughter Nancy.
Yes, and the record actually goes through this in detail. So what we have is, first of all, we have the appellee making the appointment, taking the decedent to the appointment, met with the attorney in the initial meeting. The meeting was very quick. Was aware of the contents of the documents. And what I'm going to do is I'll go through these specific things.
But the record indicates that the attorney inquired about any duress or pressure and found nothing to that effect at all. Similarly, her doctor was deposed and said that there were no cognitive issues throughout this entire relevant time frame. So it just looks like daughter Nancy took care of her mother all these years and mother wanted to reward her.
Your Honor, that illustrates a very important point in this appeal, and that is this. What the court has just cited is different parts of the record. What the standard is in the amendments for the rules of civil procedures is this. Based on the evidence that the appellants present, could a jury find? Now, the court has accurately pointed out, and what you will note in this appeal is neither the appellant nor the appellee argues that the others' cites to the record are incorrect. Nobody's saying, well, wait a minute, the record doesn't say that. What they're doing in the response brief actually supports the appeal. What they're doing is they're citing different parts that dispute the evidence. So that we cite and say, look, the appellee knew what the document said ahead of time. What you have in this record is actually quite unique, and you have the state planning attorney making statements under oath, which are then contradicted, and he contradicts himself. And he says, for example, number one, I sent it to the decedent. I sent the estate planning documents. Well, actually, when he saw his notes, no, I didn't. The Second Amendment, because you see in the facts here that what happened is the document was prepared. After the document was prepared, then the appellant came down and met with the decedent, looked at the documents and said, and the decedent told the appellant, that's not what I did. I didn't do that. One or two things are happening. When you're looking at summary judgment, we're looking at the inferences, the reasonable inference. I would submit that a reasonable inference when the decedent said that is she didn't know what she did. So the evidence that the appellant has presented, which is undisputed, does that enough to go to a jury? And we would argue that the standard clearly does. And it gets further from there. When the attorney was then contradicted, because the second time he stated that the decedent told him what changed, because remember, it was amended once, it was amended again. First, in his deposition, he says the decedent told him. Then when presented with notes, he's like, wait a minute, the decedent didn't tell me. The person that told me what to do was the appellee. So then he did what the appellee said to do, not the decedent. The appellee brings the decedent into a meeting, which the attorney then says, after being forced to because he looked at his notes, is it was extremely quick. Your Honor, I would submit that those standards, in addition, we have to add a couple others. The district courts have made it very clear over many cases that you have to look at the capacity and constitution of the decedent. Now, Your Honor, I submit, yes, you are exactly correct. One part of the record, the doctor says, no, I can't say she was incapacitated. Another part of the record, the doctor says, when confronted with difference in notes. Every time you go see a doctor, they print out these little notes that are in a computer. You order them, they print them out and give them to you. What you find with those is almost always they're the same with a date and a new sentence. What she did here, which was unique, is she changed what it actually said. First, she said good judgment. Well, the second meeting she had right before the amendment was done took that out. And she was questioned, why did you take out good judgment and good long-term recall? And she said, I must have thought those didn't apply. Well, if you look at that evidence, that clearly supports what Carpenter is saying. The presence of the beneficiary in those occasions when the testatrix expressed a desire to make a will, knowledge of the contents of the will, giving instructions, securing the witness, they didn't secure the witnesses, safekeeping the will. We have all those. If you look at the facts in the record that we started in, which were not disputed, it's sad to look at this lady. She had multiple fractures. She had broken bones over and over again. She was 94. She said, according to the doctor, that she had trouble managing money shortly before that these documents were done, both of them. What that demonstrates is diminished capacity. If you go back 40 years when she was, or 30 years when she was my age, those things wouldn't be present. The district court cases have made it clear that when you have diminished capacity and unequal bargaining strength, that is another component. So I would submit to the court that if you look at the evidence we submitted that is undisputed, that is more than enough to get to a jury, and that is the essential part of the court's error. And you
one
can
of the findings in the court's order says there's no affirmative evidence that the decedent had any judgment problems or cognitive issues at any time when the decedent lived with the defendant, which is what it appeared to me when I read Dr. Miller's deposition transcript. That's what it appeared to me to indicate. But especially at the time the decedent made the February 2019 change to the trust, hadn't she just seen the doctor within a week or two of the time that change was made? The doctor indicated that there were no issues.
Your Honor, I would submit that that is true, but I would also submit the following is true. She also said that she couldn't manage money. She also made notes of that very specific meeting where she took out the words good judgment, long-term recall. When questioned, she said, I must have believed those no longer applied. She no longer
Dr. Miller
had
took
the
care
judgment.
of this lady for 5 years and never had any concern about her cognitive ability or judgment.
Your Honor, and the other point that I would say is just what I said. So look at the evidence that we presented. We're not saying that that evidence is true. We're saying that the evidence is contradicted by other evidence. And that exactly illustrates the point. If you look at what the argument is in the answer brief, what do they not do at all? They don't at all ever say, okay? The inquiry, and this is according to page 7576 of INRI Amendments of Florida Rules of Civil Procedure, the inquiry is, under each is the same. Both standards focus on whether the evidence presents a sufficient disagreement to require submission to a jury. They go on the same page. Under our new rule, when opposing parties tell two different stories, one of which is blatantly contradicted by the record so that no reasonable jury could believe it, a court should not adopt the version of the facts for purposes of ruling on motion for summary judgment. They don't argue in their answer brief that no reasonable jury could believe the evidence we present. What they argue is still illustrates the error. They argue that you should believe this evidence, you shouldn't believe that evidence. That right there is exactly what the point is. When you have that scenario, the evidence should go to a jury. They concede the argument. And if you look at their brief, nowhere in it, they're arguing the evidence they present. They're not arguing the evidence we present, other than to make one key point, which is another component of the court's error. This is why this is so important. On page 11 of their brief, page 12, they argue this, and I want to read it because it's fascinating. In situations like this, where communications and assistance are consistent with a dutiful child towards an aging parent, the presumption of undue influence does not apply. The reason is simple. Like this case, most, if not all, of the Carpenter factors would be present in such situations. In other words, Your Honor, they concede, look, there's active procurement all over the place. We know it. But what we're saying is, because it was, quote unquote, once you endow them with dutiful child status, that wipes it all away. Well, wait a minute. Is that what Hack v. Janes says? Hack v. Janes is an excellent procedural case that talks about what exactly should happen. If you have a presumption, which you have, they concede confidential relationship, they concede that there was a fiduciary relationship, they concede that they benefited from the documents, and they concede on page 12 of their brief that, like the Carpenter, these factors are present. Just ignore their evidence, not because a jury couldn't find, but ignore it because there is a dutiful child. So let's look at what the dutiful child actually says. First of all, I submit that that rule doesn't even exist. The three cases that they cite are cases where the district courts go into a detailed analysis, because in most cases, given the case law, you are going to find a confidential relationship. You are usually going to find benefit of active procurement, but in one of the cases they cite with one brother, I think it's Carter v. Carter, one brother goes in and talks this lady into making a change that didn't benefit him at all. The other brother, the only thing the other brother did is take the lady to the attorney. Well, we can certainly concede that that without more would not even be close to active procurement as defined in Reed Carpenter, as defined in Hack v. Janes, because in Hack v. Janes it said, look, when they established 733-107 Pren 2, we changed the presumption. However, the evidence that determines whether there was active procurements in Carpenter still stands. So, Your Honor, what we have in this case is we have confidential relationship, we have active procurement, they concede it. We have benefit of active procurement, and their argument is, we have a new doctrine that's in this law review, or not a law review, it's in a Bar Journal article that says, you just call them dutiful and now active procurement doesn't apply. That's nowhere in the law, and that is the heart of the court's error. But I would submit to the court that even if they didn't concede, as they do on page 12, active procurement, Carpenter was remanded to the jury. Why was Carpenter remanded to the jury? Because the court went through and said, look, you don't have a presumption here. Then they said, but under our case law, we're going to give it back to the jury because the factors that show, even though we find them insufficient for a presumption, also show undue influence by the greater weight of the evidence. So we're sending it back. And incidentally, that is exactly what happens in every single case where a spouse is accused of undue influence. Why? Because you can't establish, for purposes of presumption, a confidential relationship, because it would always occur. No court in the state of Florida or anywhere I've found in the country has ever said that you can't establish a confidential relationship with a daughter. And I'm getting close to my time. Thank you, Your Honors. I reserve the rest of my time to respond.
Great. Thank you, Mr. Lynn. Mr. Kessler, you're up.
Thank you. Good morning. May it please the court. Brian Kessler on behalf of the appellee, Nancy Layton. Just to address a couple points. The first point I'll address is that there is no concession that there was active procurement by Nancy Layton. In fact, that is the issue of dispute. Counsel seems to ignore the estate of Kester case out of the first DCA, which specifically states, and I'll quote, where communications and assistance are consistent with a dutiful adult child towards an aging parent, there is no presumption of undue influence. So the suggestion that there's a lack of authority to support the dutiful child exception is quite misplaced.
But isn't there a difference between whether there's a Carpenter presumption and whether there's a fact issue for jury?
Correct, Your Honor. So with regard to, and what the trial court found was when you have a dutiful child, a parent, right, there can be no presumption of undue influence. Akin to relationships, Mr. Lynn suggests that, or marital relationships. Mr. Lynn suggests that marital relationships, there can be no presumption of undue influence.
But So if assuming that you're correct and there's no presumption in this case, how does that get you to a judgment in your favor versus submitting the question to the jury without the presumption?
That's a great question, Your Honor. So let's take it step by step.
I try.
The appellant would try to establish a presumption of undue influence. The presumption is negated by the fact that the court found that there was a dutiful child exception, or that Nancy Layton was a dutiful child, and therefore there is no presumption. At that point in time, the appellant would then have to come forward with evidence to either show the existence of undue influence on behalf of Nancy Layton with regard to her mother, or we could present evidence that the influence doesn't exist, right? In that situation, we'd be the moving party that does not bear the burden. In this instance, the non-moving party, the appellants, would bear the burden of proof at trial. And under the new rules, or the adopted rules, the Florida Supreme Court suggested that when the non-moving party bears the burden, such as in this case, summary judgment can be entered under two fact situations. One, the moving party can show with evidence that X is not so. For example, undue influence is not so. Or the moving party can point out the lack of evidence to show that there is undue influence. In this case, I would submit to the court that we satisfied both. Not only did we present evidence to conclusively show that there was no undue influence by Nancy on behalf of her mother, we also showed that the appellants lacked any evidence whatsoever to suggest undue influence. So we actually satisfied both of those prongs, in my opinion, Your Honor.
Well, the question is like when you have a Carpenter presumption, okay, and if that goes away, because of the relationship of the parties, which seems to me to be sort of oxymoronic, but you still have those that evidence, which I submit, possibly anyway, at very least gives rise to some pretty strong inferences. That's why the presumption was created. And so can't a jury draw inferences from the fact that, for instance, the mom here said, well, that's not what I did. I mean, that testimony is in the record. I didn't do that. So it suggests she did not know what she did. Lack of capacity.
No, I mean, the lack of capacity argument is quite
understanding. The fact that, all of these things that gave rise to the presumption, even if the presumption goes away, those things are still there.
And I would agree that the facts there that would otherwise give rise to the exception or to the presumption, but and here's the other thing too, just because those factors exist doesn't necessarily mean that a trial court is going to find that there is a presumption of undue influence, right? A trial court is still vested with the utmost discretion to determine, based on a case-by-case basis, the facts and circumstances, whether or not there is a presumption of undue influence. That's directly in the Carpenter case.
Here is a summary judgment entered in favor of your side, not strictly whether there's a presumption. I mean, it goes, what happened here went beyond that rule, that question.
So with regard to your question regarding the factors that might otherwise give rise to the presumption of undue influence, could they be an inference of undue influence? Yes, but when you look at the evidence, you look at the record, right? The trial court determined that no reasonable jury could infer that there was undue influence based on the facts that were presented to the court for disposition under summary judgment.
Are we bound by that?
Are you bound? No, because you have a de novo review, Your Honor. So you're not obviously.
So we could look at those same factors and say, well, jury probably could say, hey, how did this come to be where she says, I did not do what clearly was done? And then they start putting together, who called the lawyer, who came in, she did not have it turns out she did not have an advance copy and so forth and so on. Could a jury under those circumstances say, hey, the only person who was in the middle of all this was this sister, this daughter?
I don't believe so because of the other record evidence that there is, Your Honor. The Dr. Miller's testimony with regard to the mental cognition of the decedent right up until the time that she signed the amendment. We have the testimony of the neighbor who she told that she was going to do what she did. And then we have the testimony of the financial advisors as well, who said that she managed her financial affairs. She gave the financial decisions. So I think when you just look at it, look at those specific facts that you're bringing up, Your Honor, in a narrow tube.
Aren't you describing evidence that might support a jury verdict in your favor versus a summary judgment when we have all the other evidence that favors the other side's position?
No, I don't. So
I knew you were going to say that.
No, I don't. Only because, Your Honor, I think that when you look at the record as a whole, and given the new summary judgment standard and what a movement who does not bear the burden of proof at trial is required to show and has to bring forward, I think that was sufficiently done with the record before the trial court in this case, Your Honor. And I don't know if there are any more questions for me. I believe I addressed all of Mr. Lynn's comments. All right.
Okay. Thank you, Mr. Kessler.
Thank you, Your Honor.
Mr. Lynn, you're up.
Thank you. Thank you, Your Honor. Briefly, a couple points. Number one is the appellee's argument illustrates the central error of the trial court perfectly. He's not saying specifically in the evidence in the record regarding this lady's diminished capacity, regarding the events that occurred in the execution of the documents, regarding the disputed inferences. One inference you could call is Attorney Bacco said X. Another inference you could draw when Attorney Bacco twice on the record, undisputed, when made his statements under oath and then presented with documents said, well, wait, I'm sorry, that's not happened. She never got an advance copy. And by the way, Nancy told me the second time what to do, and Nancy could have told me the first time. I don't even know. So the jury could say, wow, nothing he did is true. I can't believe anything he says. Let's look at the other evidence we have. That's exactly the problem. So what they try to frost that over with is this doctrine, the dutiful child, which I would submit to you is complete error. And if you look at the case you just cited, the state of Kessler versus Rocco, that illustrates perfectly the other part of the error. So the appellate court in this case says fact A, B, C, D, conclusion. You cannot just cite one sentence of the decision, which is the conclusion, and then say that's the holding of the case. The holding of the case in this specific estate of Kessler is necessarily married to the facts they found. And what did they find? There's nothing in here that says active procurement. There's just no active procurement at all. We've got some kind of spreadsheet. We don't know when it was done. We don't know if this lady had anything to do with it. We have no evidence at all that she went to the bank and procured these things. Under Carpenter, there's nothing. So you can't just say, and here's where the sentence comes in, you can't just say that there was a close relationship, therefore. That's not what the court is saying in this case or any of the others. They're saying that just because she lived with her, just because there was confidential relationship, that doesn't establish active procurement. And that's all three cases that are cited by the appellee. So if you look at the actual evidence we present, uncontradicted, they have not argued, he didn't argue an oral argument today, specifically why that evidence could not establish a presumption. The trial court's error was saying, well, it couldn't, not because of our case law and our law, we couldn't because dutiful child solves all the problems. I would submit to Your Honor, this is an important case because it illustrates what can happen with a doctrine that really should be put in the grave. I will concede the rest of my time and thank the court.
Okay. thank you both very much.
Thank you.
In order to leave our little virtual space here, you need to click the leave